Hello, I'm Dr. Terry Susan Fine, Content Specialist for the Florida Joint Center for Citizenship, which is part of the School of Politics, Security, and International Affairs at the University of Central Florida in Orlando. Welcome to our Middle School Civics Highlights series. We're going to be focusing our attention on Benchmark 2.4, explain how the U.S. Constitution and the Bill of Rights safeguard individual rights. In Part 2, we will be examining the impact of limiting individual rights and the role of the courts protecting those rights. We will look at scenarios to examine the impact of limiting individual rights, and we will also examine the role of the judicial branch of government to protect individual rights and freedoms. How do scenarios help us understand these concepts? And what is the role of the judicial branch in protecting both individual rights and individual freedoms? So let's look at some scenarios relating to speech or press. We're going to first look at the reason for limiting individual rights and then the question posed by the judicial branch. First, is the speech involving a clear and present danger? Will an act of speech create a dangerous situation such that there is justification for limiting speech, even though the Constitution protects free speech? What about fighting words? Will this act of speech create a violent situation? Will it create a violent situation by encouraging others to act in a violent way? And can there be a direct connection drawn between the words, the speech, and the violent actions? What about libel? Is information about another person false, or does it make true information appear false if that information is printed? What about conflicting with government interest? During times of war, the government may limit acts of speech because of national security, such as when the government is concerned that certain information may be found out by the enemy. So consequently, what we see is that the First Amendment, which guarantees freedom of speech and freedom of the press, is not absolute. And it's not absolute because when it comes to speech presenting a clear and present danger, fighting words, presenting a concern about creating a violent situation, libel, the printing of libel, printing of words that make about another person that is false, or does it make true information appear false? And is there a conflict with government interest? And thus, can the government then restrict that speech? Let's now look at the role of the judicial branch in protecting individual rights. We're going to be focusing on voting. I have for you summaries of the scenarios relating to 3 different U.S. Supreme Court decisions. In other words, how did 3 different states or political parties, as I'll explain, how did they limit individual rights relating to voting, and how did the U.S. Supreme Court respond to those limitations on individual rights? Well, the first of these cases that we'll look at is Smith versus Allwright from 1944. In this particular case, the Texas Democratic Party violated qualified voters' 15th Amendment rights by denying African Americans from voting in primary elections. Now, this is an important distinction of words. It's very important. The 15th Amendment focuses on voting rights. Voting is the process of casting a ballot to select political leaders. Voting in primary elections is the process for casting a ballot to select candidates to represent a particular political party so that they can then run for office. So with that party's nomination. So in essence, what the Texas Democratic Party was doing was saying, look, we're not running an election. We're running a primary election, meaning that all we're doing is selecting candidates. So we're not serving a public process where there would be an outcome of who sits in government. The only outcome is who gets to run, and certainly anyone who runs for office might lose the election. But what the Supreme Court did was it created a broad interpretation of the 15th Amendment, saying that political parties do engage in a public process because they are focused on elections, which selects people to serve in government. Therefore, by denying somebody the right to vote in a primary, you're also denying them their 15th Amendment right to vote because of the connection between selecting candidates and thus then selecting office holders. So the Texas Democratic Party argued for a narrow interpretation of the 15th Amendment, but the U.S. Supreme Court in 1944 broadened its interpretation. Then we look at South Carolina versus Katzenbach, 1966. At the time, Nicholas Katzenbach was the Attorney General of the United States. The state of South Carolina was denying to African Americans their voting rights using a test or device that was rendered or made illegal by the Voting Rights Act of 1965, which codified or made into law the 15th Amendment. So the state of South Carolina was requiring that African Americans, in order to exercise their voting rights, had to take a test, and they had to pass this test in order to be able to vote. But what the Supreme Court said was that the Voting Rights Act of 1965 made into law that a test or device was now illegal, and it was a violation of the 15th Amendment to require that African Americans take this test. Now, some of you may be wondering, why would a state argue in 1966 that they could do something that was made illegal in 1965? Why would they? Well, the reason is this. The reason is that the Voting Rights Act was a federal law, but Article 1, Section 4 of the U.S. Constitution says that the states manage elections. And so what some states would do, as we're going to see in a moment in Harper versus Virginia, what some states would do is say the federal law only applies to federal elections, but the fact that we're managing these state level elections means that there are going to be people running for state offices on the ballot. We have the power to manage elections, and this is how we manage elections. And the U.S. Supreme Court said, absolutely not. The 15th Amendment applies to federal, state, and local elections, and this is a violation of this practice, is a violation of the 15th Amendment. Now we're going to look at Harper versus the Virginia Board of Elections. Poor Virginia residents were required to pay a poll tax to vote in state elections. The U.S. Supreme Court determined that these residents were being denied their 14th Amendment right to equal protection, and that the 24th Amendment, which says no poll taxes, applied in addition to federal elections, state and local elections as well. So the same logic applied that was applied in South Carolina versus Katzenbach, but instead of focusing on a test or device, we're focusing on a poll tax. In essence, what the state was doing was saying that even though something had been federally addressed, the 24th Amendment, no poll taxes, and that was in 1964, they said, oh, but wait a second, we are the states, we're focusing on state elections. Well, the Supreme Court said absolutely not, that not only is there a 14th Amendment right to equal protection, meaning that the government cannot treat people differently who are otherwise equal, but that the 24th Amendment also applied to state and local elections in addition to federal elections. So we see that in all three of these cases, the judicial branch indeed protected individual rights to vote, because in each of these three cases, the U.S. Supreme Court went beyond the language of the Constitution and went beyond the governmental location of the Voting Rights Act in order to demonstrate that whatever is determined at the federal level, whether it be a constitutional amendment or an act of Congress that was signed by the president into law, does apply to the state governments as well as the local governments. Now we're going to look at the role of the judicial branch in protecting individual freedoms. Here we see three U.S. Supreme Court cases from the 1960s and 70s. Tinker versus Des Moines focused on speech. The Des Moines Independent School District violated students' free speech rights when they decided to wear black armbands to school as a form of non-disruptive protest against the Vietnam War. So what the Supreme Court decided to do in this instance, you might be asking yourself, how could wearing a black armband be considered speech? Because the U.S. Supreme Court decided that wearing black armbands was a form of symbolic speech. So the Supreme Court set the precedent that speech could also be experienced in symbols, such as the black armbands, and thus the U.S. Supreme Court ruled that the wearing of black armbands was a use of free speech as a form of symbolic speech, and that because the black armbands were non-disruptive protest, that the students could indeed wear these armbands to school. In Edwards versus South Carolina, this was a free speech and a peaceable assembly and petitioning the government case. And in this case, the Supreme Court determined that South Carolina violated students' First Amendment rights when the police dispersed a peaceful protest against segregation. And so here we see various individual freedoms guaranteed by the First Amendment, and the Supreme Court, in its interpretation of the First Amendment and looking at a specific case, said that these free speech rights and peaceable assembly and petitioning the government rights were indeed violated. Then we look at Wisconsin versus Yoder, 1972. This case focused on the free exercise of religion. In this case, the state of Wisconsin was deemed to have violated parental free exercise rights when it required Amish children to attend school past the 8th grade. In essence, what the Amish parents said was that if you, as the state of Wisconsin, are requiring that our children attend school past the 8th grade, then you are violating our free exercise of religion, because we as a community will educate our children, but to practice our religion, we educate our children in a manner and approach and a focus that is different than what is part of what we would generally see in grades 9, 10, 11, and 12. So consequently, we see that the Supreme Court sided with the Yoder family and the other Amish families who wanted their children to not be required to attend high school, in essence, beginning in the 9th grade. Thank you for joining me for Middle School Civics Highlights. Do you still have questions? If so, please contact us using the information that appears on the screen. Till next time, I'm Dr. Terry Susan Fine. Thank you for joining me.